long-time constitution in 1814 with a personal union with Sweden until the independence of Norway in 1905. And this constitution does not foresee in its articles judicial review, but it contains two articles which have been used by the Norwegian courts, and especially the Supreme Court, to develop a kind of judicial review. Article 97, which prohibits retroactive laws and can be interpreted as the possibility to set aside a retroactive law as inconsistent with the Constitution. And Article 105, classical clause about taking of private ownerships for public works or public interest. This taking must be accompanied by a just compensation for the private ownership, and it can be also interpreted that a taking, not only by administrative regulation, but also by a statute law without compensation, is inconsistent with the Constitution, contrary to the Constitution. I use, you have guessed that it's not my personal research about Norway. I use two texts that, for me as a legal historian, were very interesting. And sorry, especially for Mats and Nas, who arrived from Norway, about the pronunciation of this Norwegian name. The work of Rune Slagstad, the breakthrough judicial review in the Norwegian system, in a collective work about constitutional review in older constitution in 1995, and a book of Ragnhildur Helgadottir, The Influence of American Theories of Judicial Review in Nordic Constitutional Law in 2006. Concerning the doctrinal point of view, these works, and especially the one of Helgadottir, has shown that there is a great Norwegian literature using the American precedents and case law about judicial review, especially one treaty between 1866 and 1885 of Aschehoug, then different papers from Morgensterne between 1900 and 1930. And more important, perhaps, there is a case law beginning in 1854, and then a second decision from the Norwegian Supreme Court in 1866 about taking without compensation, and this decision have set aside statutory laws of taking of private property because they were deemed inconsistent with the Constitution. And then I make these developments shorter to finish in a few minutes. There are many decisions about vested rights, about prohibition of alcohol, of liquor sales, a great case about waterfalls and license for waterfalls in 1918, and probably it will be discussed, a kind of decline of this first blossoming of judicial review during the first half of the 20th century. There is no comparable case law in Denmark for different reasons, with the 1849, 1866, and more recently 1953 Constitution. The right of ownership is also inviolable in the Constitution, but there is no constitutional clause about retroactive laws. The clause about retroactive laws is in the Danish Criminal Code, in the statutory law, and the case law has developed about judicial review in Denmark, according to this work, only from 1921, and from the decision itself with a low degree of scrutiny from the Denmark court. And probably you will explain about Icelandic cases, and I make just some mention of this history, beginning very early, also at the end of the 19th century. The more recent evolution are, of course, different. I don't say that they must be separated from the past history, but the past history probably is linked with the development of written constitution, the development of parliamentaries, the development of liberal guarantees of citizen rights, but also perhaps we discussed especially about Norway, about different perspectives concerning the development of the parliament and of statutory law. Probably we have to take account of more conservative views from one part of the judges and one part of the legal writing, conservative views towards the development of parliamentaries with some reluctance to the role of political parties and partisan opposition, and the idea that the courts could be a way to curtail and to frame the development towards a too quick democratization of the country. It's the question. The recent developments, of course, are linked, and it's well known, with the European Convention on Human Rights, its implementation, its incorporation in domestic law in dualist countries, and many of these Northern Europe countries are dualist countries. On the contrary, Netherlands is a modest country with a curious situation, but not very far from the French situation with the control de conventionnalité, the Dutch situation where the possibility for the courts to set aside domestic statute inconsistent with international treaties, international rules is foreseen and we can say ordered by the Constitution, whereas the possibility to set aside domestic statutes or a treaty which are inconsistent with the Dutch Constitution is prohibited by the Constitution. And it was the case to say that the Dutch democracy has worked, and probably well worked generally, without judicial review, without the classical form of judicial review, but also with the help or the guarantee of the Strasbourg Court that can work as a shadow constitutional court for Netherlands, according to the expression of Alex Wheatstone. And I have just zoomed in this board, this slide, the evolution concerning the incorporation of the European Convention of Human Rights in Iceland, Denmark, Sweden, Norway, and of course in the United Kingdom. And this evolution can be interpreted as a general trend provoked by the European Convention of Human Rights to develop new forms of judicial review, a kind of I cannot say common law of judicial review. It's why I use the Latin word jus commude of judicial review based on the European Convention on Human Rights. But probably we will have to ask our colleagues and speakers today if each country is not a special case, Sonderweg towards domestic configuration of judicial review, and Sonderweg that for one part perhaps could be explained by the constitutional and political history past, but also could be explained and analyzed through the more recent developments, and the more recent developments in some cases seem revolutionary ones. In the United Kingdom with this surprising path towards the writing of the constitution, and in Iceland with this so surprising in many European countries revision through ordinary citizens of your constitution. I hope that this historical presentation was not too long and that it has been useful, not for the speaker, but for some of the colleagues and students who are present. I repeat, with the arrival of Mats and Lars, how we are grateful to the speakers. Sarah Lambrecht will arrive later. Hello. Everyone. Sorry, everyone is present, and many thanks for coming here, and especially for speaking and working with us. I welcome you very warmly in the École Normale Supérieure, and I hope that all this day will be fruitful for all of us.
And maybe change managers. Can you find?
Yeah, I can just introduce briefly Viktor Valentin, who is a professor for constitutional law, public law at University of Reykjavik, or University of Iceland, yeah, right. In Reykjavik, but because there are two universities in Reykjavik. So, and well, she's not only an expert of the constitutional law, but she's also a person we could ask information during the lunch about the constitution making process in Iceland, because she knows everything that has been heavily involved. Thank you, Björn, please.
Thank you very much, Pascual. Yes, indeed, it would require a whole lecture to discuss the revision of the Icelandic constitution, but unfortunately it's not my task here today. But as Pascual said, we could discuss it maybe during lunch. There are interesting things going on in Iceland in this respect. But here today I'm actually going to discuss and try to clarify why and to what extent the constitutional legal theories and practice in Iceland and Denmark acknowledge powers of the general courts to review constitutionality of legislation in concrete cases. We don't have any system of abstract review. I will be focusing on adjudication in concrete cases. Can I maybe just take this here too? No. Okay. Do like this. I find we can take. So, well, being a professor at the University of Iceland, my point of departure will of course be the Icelandic constitutional system. However, due to very close relationship with the Danish constitutional system, we have common basic features and constitutional principles, so I will be covering basically both systems, but mainly emphasizing the Icelandic practice, because, well, there has been more going on, if one can say so, with respect to constitutional review, or judicial review. But it is interesting to compare different development between Iceland and Denmark with common origin. and they have partly been going in different directions, and that's mainly because in Iceland there was a complete revision of the human rights provision in the Icelandic constitution. That was in 1995, and I will explain further later on. And that actually was a big change in the whole environment about judicial review in Iceland. But going to the Icelandic system, well, Iceland is a constitutional republic with a parliamentary government. Its present constitution was adopted in 1994, and that's when, following the abrogation of its long-lasting union with Denmark. Iceland had actually been in or under Danish rule since the 14th century, started under a Norwegian rule, but later on that was changed to a Danish rule, and there we remained until 1944, basically. However, the Icelandic constitution is rooted in the mid-19th century, and the origins are closely connected to the Danish constitution of 1849. So when absolute monarchy was discontinued in Denmark, and the constitution was adopted in 1849, establishing a constitutional monarchy, Iceland started fighting for getting their own constitution, but that we were not successful in that. And after years of dispute between Iceland and Denmark regarding the demands of Icelandic constitution, basically Christian IX of Denmark, King of Denmark, presented to Iceland the constitution in 1874, and this constitution was based on the Danish constitution, basically the same document. So the Icelandic constitution of 1944 is resting to a large extent on the foundation of the Danish constitution, and it's therefore closely related in substance to the current Danish constitutions of 1953. Iceland's constitutions of 1944 and the Danish constitution of 1953 are very similar. So the Icelandic and the Danish constitutional systems, as well as the other Nordic countries, which I will briefly refer to here in the following, they rest on several basic ideas, ideological pillars. So most of those can be traced back to the 18th and the 19th century, concurrently with the abolition of absolute monarchies in Europe and the foundation of democratic governance. And what's characterizing for these constitutions today is that not all the important principles of the constitutional system are explicitly stated in the constitution itself. And even though the present constitutions of Iceland and Denmark are since the mid-20th century, they still reflect strongly their historical roots, which means that being originally written in a concise and cautious style of the mid-19th century, they also reflect a style that was intended to preserve the status and the dignity of the king at that time. And in addition, constitutional customs have developed and they are enjoying the same status as the written rules of the Constitution, and they also form a feature of the system of government. And one of these constitutional customs is the fundamental characteristic of the Danish and the Icelandic constitutional system, that the courts do have the power to perform constitutional review. In Denmark, the judicial review has mainly been reflected, though, as a principle, rarely applied. And this means that since late 20th and the early 20th century, the Supreme Court of Denmark made clear that it could exercise that power in concrete cases. So references were made to the power of the court. And ever since the beginning of the 20th century, such references can be found in the jurisprudence of the Danish Supreme Court. However, only approximately an age later, or in 1999, the Danish Supreme Court exercised that power by setting aside legislation which was deemed unconstitutional. So this was really the first time where this assumed power was exercised. However, in Iceland, the courts have exercised their power more actively, and ever since it was first applied in 1943, It has been applied in more than, we could say, like 20 judgments up to date, and it has called for reaction from the legislator to amend or repeal the legislation or provisions which have been deemed unconstitutional in judgments. Yes, I forgot just go through the slides because this was actually what I was just saying. But now I take the next slide about so what is the justification and the reasoning underlying this system of Denmark and Iceland. Well, as a matter of fact, the question of whether the courts of law should have the power to decide whether acts are unconstitutional and the source of the power and the extent has, well, like in every constitutional system, it has been one of the most controversial issues and what has been debated very much in both Danish and Icelandic constitutional theory. As we know, the traditional starting point relates to the foundation of democracy, or that decision of the legislature are made by the democratically elected representatives of the nation, whose will is manifested in the decision of the parliament. For this reason, the principal argument against the judicial review has been that it is undemocratic, that the courts interfere with the legislator and decide whether acts of law are constitutional or not. Well, furthermore, judges are not accountable to the citizens for their decisions in the case of democratically elected compared to democratically elected representatives. However, the arguments, the counter-arguments supporting the powers of the courts of law to watch over the legislature and decide whether an act violates the Constitution has gradually carried more weight in most democracies of the world, including Iceland and Denmark. And what is of greatest significance here is basically another unwritten principle of our Constitution, which is the rule of law, slightly mentioned here by Jean-Louis before. And this has gained more importance in these countries as well as in all European states. And there are further reasons for that. The rule of law is one of the pillars of the Icelandic constitutions as an unwritten principle. One of its main objectives is to secure the rights of individuals to obtain a resolution by an impartial court as to whether the holders of government powers have exceeded the limits of their powers. There have not been any specific problems with controlling the executive power, as was also mentioned here before. There are decrees and administrative decisions that there is a longer tradition in Iceland and Denmark that these decisions are subject to control, the executive decisions. However, the legislator is also being scrutinized, and this is with reference to this particular principle, the rule of law. So, the right of access to an independent and impartial court and due process is secured as an independent human rights in most constitutions and also in the Icelandic constitution. And in addition, the rule of law requires that the appointment of judges and the work of the judiciary is designed to ensure their independence from the other branches of government. Following from the principle of rule of law, it seems to be a generally accepted view that the constitutionally protected individual rights and freedoms are better secured if the courts are entrusted with this power of review. And furthermore, the growing European cooperation in the field of human rights, particularly the practice of the Strasbourg Court, has undoubtedly encouraged this development. The obligations of member states to the European Convention on Human Rights to provide an effective national remedy to resolve whether human rights protected by the Convention have been violated in individual cases. This is an important factor in this context. It is putting pressure upon the domestic courts to resolve questions related to constitutionality of statutes, at least with respect to human rights. So, entrusting powers of judicial reviews to the court confirms the approach that human rights provisions are rooted in certain values of a democratic society, which are equally binding for all branches of government and also the legislature. The Constitution preserves these values and is also the supreme source of law. Therefore, the courts of law are required to set aside any act of law that is in conflict with the instructions that are ingrained in the Constitution, and they must give precedence to the superior law. So this supports the argument for acknowledging that the courts should determine whether the conditions imposed by the constitutions are met. And the idea of the rule of law as one of the principles of Iceland and Danish governmental system is therefore closely connected to the foundations related to the objective of the theory of the division of powers, and that different branches of government should serve as checks on one another, particularly with respect to human rights, once again. So, then looking into the practical part, who is basically, which bodies are exercising the judicial review in Denmark and Iceland? So, the arrangement of conferring the powers of reviewing legislation, of course, is differing widely between countries. In Iceland and Denmark, the general courts are given this task, and you will not find any specific system of constitutional courts or similar to what we can find in some European states. Well, this is partly due to the fact that the system of judicial review in these countries, in Denmark and Iceland, is basically judge-made. It's made in the practice of the court. And it was not foreseen as an organized element of the constitutional system in the mid-19th century when the constitutions were adopted. So this developed in the court practice and jurisprudence of the courts of Iceland and Denmark, starting in the late 19th century and also in the 20th century, but even earlier in Norway, as well. And this can be traced even back to 1866. And Norway basically has, in some aspect, a different tradition, which I'm looking forward to listening to here afterwards by Mr. Andenes. Because in Norway already there was more tendency or influence to accept that the courts possess the powers to review the constitutionality of acts of law, and specific influence that can be traced to the United States Constitution and developments of constitutional government in America is more apparent in Norway, which actually has the oldest constitution of Europe, adopted in 1840. So it is in the hands of the general courts, this power. So then if I would go more into discussing where do you find the source of the authority? Where is it?